afternoon. As you can see, I am not Tom Leather. I have some hair and no goatee, and he has a much bigger smile than I do. As the slide says, he is the founder, managing shareholder of Leather Law. I've known Tom for close to the 35 years that he's mentioned he's been in business. I met him as a contractor doing a large, very large insurance claim for Farmers Insurance. He was the attorney for Farmers, and I've known him, been an expert witness. He had to prompt me for a defense with a public adjuster. So he's been involved in lots of legal cases that revolve around contracts. And that's why I asked Tom to help me with the presentation, because contracts are indeed legal documents. So me, I've been a SCORE mentor. I'll go in reverse. I've been a SCORE mentor for this is my 7th year. I started a very, very small carpet cleaning business where we didn't have contracts. We would clean carpets for about $9.95. That grew quite a bit, did asbestos abatement when asbestos became a hazardous material, and had a lot of exposure to contracts, which I'll talk more about then. As opposed to people signing our contracts, we signed other contracts for the Port of Seattle, for Weyerhaeuser, companies like that. My partnership went a direction I was not comfortable with, and I ended up leaving that business, and I got into a business. I bought a small family business that did disaster restoration, which is where I met Tom, and worked mostly with insurance companies. Not always insurance companies, but they were ultimately, in many cases, the bill payer, as they were insurance claims, and we were paid by the client that we worked with. I was fortunate enough in 2003 to be approached by a company people might have heard of, called Coit, that did a lot of residential and commercial cleaning, and they wanted to be in the disaster restoration business, and they bought my business in 2003. And after 11 years of working for them and working with insurance companies, and turned 65, it was time to retire. And after a year, I ran into SCORE. I've been doing that for, like I said, my 7th year. And I end up getting now lots of small contractors with a variety of questions. And in many cases, the question are, what is a contract? Well, a contract is a legal document, and that is really why I had asked Tom to come. And I should stop for a second. He's not talking because he's not here today. An emergency came up. So I will be telling the stories that speak to some of the issues, but not being an attorney, I will defer a little bit for some of these questions that may come up later, and I can get answers if they're very specific to legal things that I just can't answer. But a contract, as it reads, it's a promise to perform between two or more parties based upon a mutual acceptance and supported by valid consideration. It is a legal document, and in some ways it's simple, but not necessarily easy. The elements of a contract have 3 components: a promise to perform, mutual acceptance, valid consideration. So let me give you an example of that. My wife and I had a fairly large remodel done a few years ago, and the promise to perform, the general contractor worked off an architect's scope of work, and these are the things we're going to do. They wrote that out. There was a budget for that type of work. I signed the contract. I agreed to do this. They wrote up the verbiage in a contract form, which I signed, meaning it was mutual acceptance. And the valid consideration was that I agreed to pay them the price that they quoted for the work to be done. Elements of a breach of contract. So the 3 topics that Tom came up with: breach, damages, proximate cause. The breach basically is, and it's going to be in most cases, that the contractor fails to perform the work that they agreed to do per the last bullet point, the contract. Damages are defined as what wasn't done. If the contract talked about, as an example, $15,000 for a certain component of the job, and that wasn't done, let's say only there was $5,000 for part of it, $10,000 for another. The $5,000 wasn't done. The contract was not fulfilled. It was breached. The damages would be the $5,000 that wasn't done. Damages would not necessarily speak to if there was an accident and they burned the house down. That would be, we'll talk later about insurance, but that isn't necessarily the breach of contract. So don't confuse an accident or damage that's done to the property while work is being done as a breach of the contract. The term proximate cause, again, this is, I wish the lawyer here was to present that. He's not. To do the best I can, it would be harm that is reasonably and foreseeably and connected to the action that was being attributed to it. Sounds like a lot of legalese, and that it is. And again, at the very end of the presentation, you can send some questions. I'll do the best I can to answer the legalese. And I should say that Tom, again, had the emergency today. He won't be available for questions after either. What would be a defense if you are performing for a client and they say you breached the contract? Well, one is that you did basically disagree on their allegation that you've not performed or fulfilled the scope of work that you agreed to do. Maybe an argument about what you see a lot of arguments in the world today, but they said you did not do something per the terms and conditions of the contract. You can then demonstrate, well, yes, indeed, we did take a look here. What would a mistake be? A mistake would be when both parties make an assumption that influences the central component of a contract that can't be fulfilled. I'll give you the example of the remodel that I had done a few years ago. This didn't happen to us, but this would be an example of a mistake where the remodel is being done too close to the property line, and a significant amount of the contract being written up is to perform work that is too close to the property. It comes to light by the next door neighbor that you're in violation of building code. Well, this was an honest mistake and that there's no longer a breach. The defense is there was a mistake that was just unforeseen to both parties. Public policy could be construed as a little bit different. Example I looked up online was when two parties agree to have a party at a public space, they lease a liquor license together, but that is against state policy. So those are some examples of mistakes and breaches of public policy. Contract remedies. So there are 6 bullet points here, and these really, again, when I submitted this was described as fairly lawyerly, and indeed it is, and you'd expect no less from a lawyer, and that's because that's what he does, and he has to put some of these things out here. I'm going to talk in general terms about all these, and I'll give some specifics towards the last 3, or 2 of the 3. For the vast majority of people, I think, that are attending this session, these will never come up. These are much more likely going to occur if you have signed a contract for someone else, as opposed to if you're having a contract with a homeowner or maybe a small, a commercial client. One of my clients in SCORE does lighting, and he has some contracts with the city of, not city of, but with Ballard to hang Christmas lights. It's a pretty simple contract. I'll give you the kinds of instances when these come up would be on much larger commercial clients. And again, I pulled something up online when I realized Tom couldn't be here. Express remedies. I can read from something I picked up off the web. Express remedies: if an event or default occurs, the leaseor at its option may do any or all of the following: proceed by appropriate court action, liquidated damages, not a penalty or leaseor. It's really, really legalese, and it's highly unlikely you will end up in any of these first 3 issues if you have contract disputes. Liquidation of damages I can speak to personally, much more typical in public works when, per my resume in the late 80s, we had a contract, the company I owned had a contract at the Port of Seattle where we were doing $350,000 of asbestos removal at the airport. That contract the Port of Seattle issued to us gave us a time frame within which we had to complete the work per the scope of the contract. There was a time frame to do that, and there were daily penalties for not completing on the day that we agreed to. You're not going to find that I would be surprised if anybody ever experiences that in their contract life. It's mostly going to be with very large contractors or public bodies. Attorney fees, not surprisingly, when the attorneys get involved, they want to get paid. And again, I'm sorry Tom can't be here to address these really legal things. I'll say it again, feel free to submit questions at the end. And if I can't get the answer, I'll have your email and I'll get that answered for you. And again, I do apologize for that. Liens. Wondering how many have heard of liens. The liens are usually filed on construction projects. If you have questions, those of you that are contractors, I would encourage you to reach out to your representative with Department of Labor and Industries. They're not there to harass or fine, they're there to help. A lot of people don't realize that when you're doing building projects, the state of Washington does require a lien notice to be provided to the client before you start repairs on their home. Without providing the lien notice in advance, you are not able to execute a lien. Those are for construction liens, as the first bullet point says. The second one is for services performed. If you left your car at an auto shop and did not pick that up or didn't pay, they can provide a lien for services performed on construction jobs where architects are hired to write plans and specifications for the work to be performed. If they're not a contractor, they're an architect, but all kinds of services are subject to liens being attached if the client doesn't pay the bill. And not surprisingly, here's the attorney again that wants to make sure he knows that he has legal actions to be paid if he's not being compensated for the terms and conditions of the contract. Although this next slide, importance of clarity, is a very simple slide, and the word simple is there, I cannot speak enough to how important this is. And I would push back a little bit on Tom about the be creative. I think the more simple and clear it is, the more important it is. It isn't just in my 40 years of being a contractor and being in disputes and being aware of disputes that it is the scope of work, what you are supposed to do, what you've agreed to do, back that very first bullet point about the contract, the consideration, what you're going to be doing. This is where many disputes arise because it is just not clear to the client or maybe to you what they expect to have done and what you expect to do. So I cannot speak enough. It isn't just my work experience, it's my 7 years approaching of being a SCORE mentor of getting a lot of contractors, that this issue of scope is critical. So I'm going to pause for a second, see if you walk away with anything today. Think about the scope being important. And again, we're talking about written communication. Communicate, communicate, communicate. So clarity, communicate, and then hopefully you will walk away with one last point is you do work with an attorney to make sure you do have a contract that meets the expectations that you have and who you are and what kind of business you have, and I'll get back to that a little bit. But walk away with this if you have to leave now. Clarity, communicate, and have an attorney help you with these documents. So you want to hire them once, hopefully, and not be have to hire them again because you haven't done as good a job as you wished you had on the front end of that. So simple, clear, communicate. Oh, shockingly, importance of communication. pre-contract discussions. Now, I know a lot of clients, I have a lot of clients I have, the jobs are fairly simple. I'm in my office at home right now. I'm looking out on from my upstairs office, and I can see that the roof was cleaned. There aren't a lot of contract discussions about cleaning the roof. There are some, actually, how it gets cleaned, when they're going to come, shockingly, communications during performance, post-preliminary discussions. But I think that this communication topic, we know it in life, it is just so important. And I would echo, this isn't so much about contracts, but I think if you're going to err on one side or the other, over communicate, not under. Over the years, I know clients get frustrated. They may like the quality of the work, but they're frustrated because they're kind of left hanging. They don't know what's going on. They're not being talked to. And those kinds of negative feelings can end up being a catalyst for situations that require attorneys at the end, because the clients are frustrated or disappointed with how the project has moved forward because the contractor has not communicated with them. So make sure this pre-contract discussions clearly focuses on what you're going to do for the client. Because in my experience, again, both as a contractor, but now as a SCORE mentor, this is the biggest component of problems. It just is not clear. Well, I thought you were going to, no, I thought you were going to do this. So communicate. Tell them what you're going to do, tell them again, and tell them one more time just to be safe. The problem with change orders: communication and clarity. Documentation. I'm going to use a story to illustrate how important this is. We did a job, an asbestos removal job years ago for a large building owner manager in the local area who will remain nameless. This was an older building in Seattle. It was all concrete. There was a sprayed on acoustical concrete. To the concrete ceilings of the top floor was this asbestos material. The walls, the top foot of the wall, the butts, the roof of the building, there'd been moisture penetration, so it was all wet and funky, and we were supposed to scrape the asbestos popcorn material and take out the top 2 feet of wall on the exterior walls that were obviously wet. When we took those walls out, we saw that, again, a concrete building, it was metal studs. The metal studs in some places were rusted out and actually gone. We stopped the job. We had the owner of the company come out, the architect come out to look at the problem. We agreed on a verbal scope of work to be done. My project manager failed to execute a written change order, and I will come back to what happened with that later on, but you can make a wild, educated guess that there was a problem that occurred, even though it was agreed upon the third party, the owner, we could visually see what was going on. The agreement, by the way, was to take out a few more of these studs that were no longer weight bearing because they were rusted out, but to take those out totally. And again, I will come back to this story a little bit later here. Some of you may have subcontractors, and this is going to be something you're going to want to talk to your attorney about. You're going to want to have the expectation just with them. You're going to want to have the rules of the road. Are you going to let them smoke on the job? Are they responsible for their cleanup? I mean, all the things that you expect of them need to be written up in your subcontractor requirements. I'm going to talk a little bit more about insurance requirements, but this is really, really important. In worst case scenarios, if they burn a building down and they have a terrible accident, that whether it's personal property or injury, and their insurance limits are not adequate to cover the damages that have been incurred, guess who is responsible? That would be you. So this is all for those of you that are hiring subcontractors. You want to make sure you talk to your attorney about how to make sure you're protected by your subcontractors. And one thing to add that's not on this, make sure they're licensed and bonded. It's a good time to remind myself that for you, that some of you, businesses change over time. You might never envision yourself being a subcontractor or working for someone else. And never in my wildest dreams as I started as an asbestos contractor did I ever expect to be doing a $1.1 million project for Boeing. They never expected to do almost a $500,000 job for the Port of Seattle, and the contract requirements that they're issuing us for these types of topics listed made us pause and do some good reviews. So whether you're a sub to someone else or you are hiring subcontractors, you need to look at the terms and conditions if you're a sub. And again, I encourage you to speak with your attorney if you're going to have subcontractors, what your business is, so your attorney understands that, and you come up with the appropriate protection. I'm going to go back 1 second. No, I touched on that. Sorry. So just because you've written a contract, you've performed to the terms and conditions, it's timely, the quality of work is above and beyond industry standards. That doesn't always mean you're going to get paid. Some of you might not have experienced that, but I know industry standards are that a lot of companies will budget 2% for bad debt they can't collect. So you want to put all of this language in your contract about how you expect to be paid. If it's a large job, is it monthly? Is it percentage of completion? Is it upon completion? Is it every 2 weeks? If someone is short of money, will you extend them time and charge interest? And then you're going to want to have, oh, here we have it again, attorney's fees will need to be in there. There's one thing I'm going to back up a second. In your contract, I apologize for being out of order here. In your contracts, you might want to have disclaimers, things you're not responsible for. I have a couple reminders about that asbestos and that mold and that rusted out metal studs that were supporting the building. We didn't get paid totally in that job, which I'll come back to, because on one thing, we didn't have a disclaimer that we were not responsible for any structural damage. Usually taking asbestos out, it's just scraped insulating material. That client held back $16,000 on the job because he alleged we damaged the building. If we'd had a disclosure in that contract, it would have helped. Again, I started repeating myself, a painter. I have a couple of painting contractors. They deal with bubbling paint. They have some contract language in there that's a little fuzzy. They're responsible. If a painter knew there was a potential issue with paint bubbling on old siding, they should, as an example, I would suggest if you have a situation similar, you highlight your contract, you initial it, you have them sign it. So if something does get contentious, you'll be on firmer ground when you've pointed out you have the disclosure, you've identified it, you've communicated it. That will make your argument much stronger than someone else's, your clients. Disputes. Something really important to the language you put in there is important for your attorney to understand your business. These are all options, and I'll speak to why. Hopefully, you never have to get an attorney involved. You can sit down if your communication's been good, you've communicated well, they like you, there's issues with the work, then you can resolve that. A lot of times it's just a negotiation. Well, there's, the deck didn't come out quite as well as I liked. It's starting to rain. And just give me a couple $100, or you damaged this tree. It's my favorite tree. I'm looking at these oak trees, fir tree or cedar trees. You can negotiate some problems. Hopefully you can negotiate them, and you've just come to a mutual agreement. You document that. The contract was for $12,000. You've had some damage. Okay, we'll take $11,600. We agree, and we're done, because as we get to the next bullet points, it just gets more expensive. And I'll speak to what I have with my contract with a friend of mine, a good friend, who was a high-powered attorney that did all of the quadrant land stuff. So he's working on multi-million dollar deals. Our work authorization / contracts had language in there. If we couldn't agree, it would go to arbitration and/or mediation. And I would suggest for companies that are doing smaller work, you might not want to do that. And I'll give you an example why. We did use that binding arbitration when we had a very large dispute of $25,000, $30,000 on an insurance claim. And it went to AAA arbitration, and it was an interesting process, a couple of days. It cost us some money, and we came to an agreement that was a legal agreement through the mediation company that was dictated by our contract language. I'm going to guess that many of you, if you have problems, will end up in small claims court, which the cap for that is $5,000. And I would reiterate it here again, the importance of documentation. When you go to small claims court, you go by yourself. You provide the reasons why you felt that you weren't paid enough. The better you document, the better your case is, the more likely you're going to win. Small claims courts have a cap of $5,000. After that, you have to go to litigation. Back to the comment about having your attorney look at your contract language, the very last small claims issue that I was involved in, the judge was very detailed. She read through all the language and said, you can't be here. Your contract says you need to be in mediation. It's about a $4,000 argument, but the cost to go through mediation, it didn't pencil money wise. So it's important to speak with the attorney, that they understand your business and what your risks are. Litigation, I've got a few stories here about that asbestos mold job with the developer, with the owner manager of the building. He was acting in bad faith. He knew exactly what the issue was. He gave verbal approval, but we failed to document. Our contract didn't have this language about disclaimers, and the project manager did not issue a written change order, which, I'll repeat that again, you have change orders, you better write them, you have to write them up. They have to be clearly articulated and signed, just like a contract. It's not basically a second contract, but if you don't have it signed and it's only verbal, it's going to be tougher to enforce if you find yourself in a small claims court. So back to this example here, we had a $40,000 job and they held back $16,000. That was basically unreasonable. I know we would have won that if we went to court, but how many times did I see these attorney fees in there? And a lot of courts will not really grant attorney's fees. So I would encourage you to do all you can to avoid litigation at all costs, because even if you win, you're likely going to lose, and it's important to separate the emotion from the actual reality that you have you've won, but you've paid to win, which you don't want to do. There's a problem with collections. So the better you document, find out when you expect to get paid. If they're not getting paid, I've got a lot of experience with this. Find out why, when, and then there's going to be a point where you can just tell you're not getting paid, and then it's small claims if under 5,000, and then if it's over 5,000, then you might want to speak with an attorney and discuss your case and decide how to proceed with that. Some other things that aren't contracts per se, but are where I see sometimes bigger risks, where I've had a client that didn't realize they needed a commercial auto policy. They just thought they're driving their car or truck to the job site was adequate. It's not. So insurance, look at your insurance, additional insured. If you have a subcontractor, you want to speak to your broker to work with them to have you named as an additional insured. Insurance binders are just temporary documents if you don't have insurance. Duty to defend your indemnity. I know I'm starting to run out of time, so you can send me some questions in the chat and I'll do the best I can to answer these. And some might be a little too legal for me to answer without being an attorney myself. So again, I apologize for Tom not being here. So I will see you in the chat. Thank you so much for attending.